Welcome to Marriage Unbound, Divorce and Royal China, which is our first in our speaker series, our guest speaker series for the U.S. Asia Law Institute at NYU Law School. I'm Catherine Wilhelm. I'm the executive director of the Institute. And we have two audiences today. One is online watching on Zoom, and the other is right here in the room with me at the law school. It's our first hybrid public event that we have ever tried. So if there are any hiccups in person or remotely, please be patient with us. We're going to learn from today, and but I think it'll go well. So the book that we're going to talk about is Marriage Unbound: State Power, State Law, Power, and Inequality in Contemporary China. I don't know if you can see this online. It's just been published by Stanford University Press, and our speaker is with me, Kali, to use the Western order. And before I introduce her, just a few advertisements from the U.S. Asia Law Institute. Tomorrow on September 16th, for NYU ID holders only, we're holding an in-person talk called Asian Legal Careers, a Conversation with Lawrence Bates. Lawrence Bates was general counsel for Panasonic, the Japanese multinational, and also for GE for decades in Asia, mostly in Japan, and worked as in-house counsel. And he's going to talk about how he got into those positions and what he learned on the way. So this is for NYU ID holders. And then next week, Thursday, September 22nd, we will have a virtual only program with Hyun Bang-shin, who is professor of geography and urban studies at the London School of Economics. Professor Shin studies urban development, displacement, gentrification, housing, the right to the city, and other related topics with special attention on Asian cities. He's going to talk about Seoul as a case study. And Professor Shutong Xiao from Duke University is going to be the moderator and discussant. Professor Xiao is also an expert on urban development, property rights. So today's speaker, Professor Kali, is assistant professor of political science at John Jay College of Criminal Justice, and she researches law and society. In contemporary China, she's focused on divorce litigation, LGBTQ impact litigation, which we'll have to have you about on another occasion. That's a new and interesting area. And also doctor-patient disputes, also fascinating. So she earned a LLB from Nanjing University and a PhD in sociology and criminology from Indiana University. So today's book is based on extensive field research in courts, in legal worker offices, and interviews with divorcing couples, particularly women, in the countryside in Sichuan province. And it's a dense book. It's packed with information about divorce litigation, and about a whole bunch of other related things that we'll unpack a little bit today. So with that, well, I'll just explain the format. She's going to make a presentation, then I will ask her some questions to sort of try to develop more some of these themes, and then we'll take questions from the room here and the room online. So sure. The floor is yours.
I'm gonna take off my mask.
Yes.
Once I'm done with talking, I'll put it back. Catherine, thank you for that introduction, and thank you for inviting me to talk about my research. And also I want to thank everyone for coming. Recently, my book comes out. Here's the cover. And it's really nice that Catherine just said something very nice about the book cover. And the heart of this 15-year book project is a firm belief that divorce, similarly prosaic, provides a unique window onto phenomena of great importance to sociologists, political scientists, social legal researchers, and China scholars. In a sense, divorce is so much more than the dissolution of marriage between two individuals. And to get across that idea, today I will review one divorce trial and use that trial to illustrate several large consequential trends that have been unfolding within and outside of Chinese courts. So on February 24th, 2011, I witnessed a divorce trial at the Qingchuan People's Tribunal in a rural county in southwest China. Around that time, I was hoping to document Chinese judges' language use in court proceedings. So minutes into the trial, I started thinking how many times the judge interrupted the plaintiff, a rural woman named Lan Yu. And the trial lasted for 30 minutes or so, and the judge interrupted Lan Yu nearly 24 times. And that didn't surprise me. By that point, I had spent over a year conducting courtroom observations. So I was aware that Chinese judges routinely invoke certain rhetorical techniques to maintain topic control and to induce, sometimes suppress answers from litigants and witnesses. What I didn't anticipate was that immediately after the trial, the judge approached Lan Yu's counsel, and this is what the judge said to the counsel. The plaintiff brought up issues of debts and marital property division, but didn't turn in any evidence, what I'm supposed to do. So why don't you tell your client to withdraw her case? Turns out, making plaintiffs withdraw all their complaints and rights claims and concluding their cases through a procedure called withdrawal has become an integral part of Chinese judges' toolbox in handling civil disputes. So since the mid-70s, judges across the country have increasingly relied on withdrawal to dispose of civil cases in general and divorce suits in particular. Yeah, the next slide is the graph.
First slide, please. Or I'm sorry, it should be this. There we go.
Here we go. So this is the graph I want to show the audience. So pretty much between 1974 and 2018, the portion of first instance divorce suits that landed in withdrawal jumped from 5 to 25%. And how did the court system arrive at these levels of withdrawal? Why judges routinely invoke this procedure despite resistance and reluctance on the part of divorce petitioners who often have to go to great lengths to bring their cases to the court system? What has incentivized Chinese judges to favor this procedure whose rights are abrogated and whose interests are best served? In the book, I address these questions in chapter 5. Here, I just drop a hint. Drawing on archival and ethnographic data, I argue that Chinese judges have been legally, organizationally, and politically incentivized to use and very likely overuse and abuse withdrawal in divorce litigation and beyond. In doing so, judges have a lot to gain but little to lose. I should point out, judges' preference for withdrawal has generated a distinctively gendered consequence. Throughout the country, over 70% of divorce lawsuits are initiated by wives as opposed to by husbands, according to the Supreme People's Court, the highest court in the country. So this is to say, when judges try to conclude divorce cases through withdrawal, more often than not, they block women's, not men's, access to justice. So going back to Lan Yu divorce trial, on that day, while the judge tried to close the case through withdrawal, Lan Yu had no intention to do so. As a migrant worker making meager wages, she had worked really hard to afford legal mobilization, to pay for litigation. She has served as a kitchen helper in a diner in Chengdu, a city hundreds of miles away from her village. And to attend to her court proceedings, she took unpaid leave, commuting back and forth between her workplace in the city and the court in the countryside to replace a missing marriage certificate, a piece of paper necessary for divorce litigation. She badgered village cadres until they issued a written statement to verify her marital status, not to mention to rally her adult children. She had a daughter and a son. So to rally her children behind legal action, she put herself through really painful conversations with family members. All these efforts would have been in vain if she simply quit litigation. So in the end, it became very clear to the judge that Lan Yu would not give up, that neutral could be secured. Instead of urging Lan Yu to turn in proper evidence and retrying the case, the judge immediately ruled on the case. She rejected Lan Yu's divorce petition along with all other rights claims. So again, here I want to emphasize what happened to Lan Yu is not random or unique. Her courtroom experience speaks to another big trend inside Chinese courts. Inside this graph, there are two parallel developments. You see all the bars? They stand for the number of divorce petitions accepted by the court system year by year. And all the dots represent divorce approval rates. So basically, on the one hand, courts in the reform era have opened their door to more and more divorce petitions. On the other hand, judges since mid-2000s have become increasingly reluctant in approving marital dissolution, with divorce approval rates dropping from 67% in 1985, that's the highest point in the reform era, to 47% in 2018. So statistically speaking, we can roughly say it's getting harder to get a divorce inside Chinese courts. It's not getting easier. And these two parallel developments, I argue, points to the complex roles the court system has assumed. On the one hand, judges want to uphold citizens' rights to divorce. On the other hand, judges also strive to mount a public defense for the institution of marriage. So this is to say that in recent years, whereas other state bureaucracies have gradually retreated from citizens' intimate lives, the court system has embarked on a very different course. Rather than downscaling public oversight of marital dissolution, the courts have beefed up their scrutiny of average men and women's intimate lives. These two parallel developments, I further argue, expose certain systemic problems inside the Chinese courts. The Chinese judiciary as an institution, I believe, has become stuck in certain contradictions and inconsistencies. On the one hand, time after time, judges have been told that they should safeguard citizens' rights, including their rights to marry freely and to divorce freely, because such individual freedoms have been enshrined in Chinese law. On the other hand, the same group of judges, according to the Chinese Communist Party and the Supreme People's Court, should contribute to the so-called harmonious socialist society, and they should do so by turning away divorce petitioners through withdrawal, by adjudicating against divorce, by stalling marital dissolution among citizens, and most crucially, by upholding the PRC's vision of marriage as a cornerstone central to the cohesion of the Chinese nation state. Suffice to say, there are considerable tensions and contradictions among these expectations. And in the book, I make it clear, while Chinese judges find ways to stay above the fray amid all these contradictions, women who make up the bulk of divorce petitioners come to shoulder the negative repercussions. And among these women, very few find their courtroom experiences empowering, fair, or equitable. The vast majority, at least the vast majority in my study, walk away from divorce litigation with their faith in law in tatters. So finally, I will use Lan Yu's divorce trial to illustrate one more trend outside Chinese courts. In the past decades, Lan Yu and many other women have increasingly taken their conjugal problems and rights claims to the courts. The fact that citizens increasingly turn to courts for judicial remedies, I argue, should not be viewed as evidence indicative of an authoritarian state turn toward law. Similarly, I argue we should not treat official efforts to revitalize mediation and other extrajudicial measures for dispute resolution as evidence indicative of a state's turn at law. So to put it more succinctly, my point is the PRC over the past decades did not really turn toward law or turn against law categorically. Instead, what the PRC's ruling elites have been doing is they learned how to juxtapose legality with extra legality. More specifically, in the book, I show that how ruling elites over the past 2 decades have fortified judicial, quasi-judicial, and extrajudicial institutions, by and large at once, in hopes that they can deploy different institutions to tackle different problems in ruling. Under Xi Jinping's watch, PRC's top decision makers have cultivated a multi-pronged system for dispute resolution within the system, officially designated difficult or hard bottom disputes such as discontent over land taking, labor rights, and medical malpractice. These disputes are routinely channeled into quasi-judicial and extrajudicial institutions in the name of social stability. In the meantime, mundane and frequent disputes, including marital disputes and torts, are often thrust into courts in the name of socialist rule of law. So this is to say that top decision makers have been incredibly pragmatic in their efforts to mobilize both legal and extra-legal methods to address popular grievances and disputes. And again, in the book, I argue that this type of pragmatism, on the one hand, has rendered the regime very resourceful, resilient, and adaptable. On the other hand, when you treat legality and extra-legality or judicial, quasi-judicial, extrajudicial institutions as if they were so malleable and mixable, right? You can use all to solve different problems. That pragmatism has also generated unintended consequences. So all of this is to say that it's one divorce trial, but I hope that divorce trial can illustrate some larger and more consequential social and political processes in China. And in the interest of time, let me just quickly circle back, reiterate this point. Divorce, when seen through certain conceptual lens, can shed so much light on law and politics, power and inequality, and culture and state. These are the key parameters in my analysis. So I'll just stop here. Hopefully my book invites readers to think about divorce in a whole new light. Okay, that's all I have.
Thank you very much. Jess, you tell me if that's in focus. Okay, that was terrific. Thank you for exceeding my expectations and being able to compress your complex research in the very small amount of time that I allowed you. And I apologize for that. You know, I was familiar with a lot of the facts that you touch on, you know, that divorce rates are rising, the large number of women who are leaving their villages and working out, the stresses that puts on families, the way judges operate, and yet, and for example, the lack of enforcement of the anti-domestic violence law. And yet when I read your book, I was shocked by the evidence you've amassed for just how deeply gendered this area of law is. And I have to assume more broadly You know, if you were to do a similar kind of study of other types of litigation,
Yeah.
I have to ask myself, well, are we going to find some of the same phenomena in these other areas?
Yeah.
But you focused in your opening remarks on the difficulties that women have simply in getting the divorce.
Mhm.
But then in the book, you also talk about the terms of the divorce. And that's another whole tale of woe. Can the woman get custody of her children, even shared? Can she get a piece of the marital property? Frequently, there's farmland involved. Can she get farmland for herself so that she has something, you know, basically a key asset for herself going forward to start her new life? Can she get a bit of a piece of or value of the homestead, the JGB, where the family has been living, the family home? And you found that usually the answer to these is also quite difficult. And in the case of land, no. And in the case of the custody, not very successful. So in our discussion, I think we can unpack some of these individual different aspects. But just really quickly to understand the larger picture of divorce in China, do you happen to know, and I'm sorry because I didn't ask you in advance about this, do you happen to know what the divorce rate in China is for rural areas? What percentage of rural marriages end in divorce? Is that a statistics that has been calculated to your knowledge?
At least to the best of my knowledge, we don't have that kind of national statistics.
Okay.
And the Ministry of Civil Affairs lump all the statistics together, right? So we're not really able to unpack the divorce rates for the urban population and those for the rural population. And I wonder if survey researchers have certain answers to the question, but no, I'm not aware of that kind of statistics.
What's the overall national figure? Do you know that?
We would have to calculate, I believe in the epilogue, I talk about crude divorce rates. So this is the number of divorces for every 1,000 individual. And I believe by 2018, the crude divorce rates in China had exceeded the kind in the United States. So this is to say that I weekly remember it's for every 1,000 individual, there are roughly 3 divorces in China. And by that point, the US had a crude divorce rate around 2.8 or so for every 1,000 individuals.
Right.
So this is to say, again, statistically, divorce is more common in China than in the US.
Which I think is unexpected for a lot of people because we think of China as being still relatively more traditional, you know, than the US. And also I want to highlight, because not everybody may have caught this point, that we're talking about contested divorces, right? So the fact that we're talking about being in court at all means it's contested. There is a fairly straightforward administrative procedure for going to the Civil Affairs Bureau, wherever you live, and you submit the paperwork. It's gotten more complicated now because there's a cooling off period there as well. You have to come back twice. You can't do it the first time you go to the office, but that's fairly straightforward, and it's a no fault kind of an arrangement. And those numbers are rising. For the vast majority of divorces are non-contested. So that still is going on. Do we know who is getting the non-contested divorces? Are they equally urban rural, or again, is this a problem of not having the data not being collected?
Yeah, I will first take a step back and reevaluate that categorization, right? Because usually we think, oh, there are 2 types of divorce, contested or not contested. And if a divorce is contested, you go to the court. Otherwise, if both the husband and wife agreed on divorce and other things, you go to Civil Affairs Bureau. That's a very convenient, straightforward classification, but I would say that's pretty problematic. Why? Because oftentimes upon divorce, 2 parties would have to negotiate on a couple of things, right? And it's not like every couple or every husband or every wife has the resources and the opportunities to use the court. So this is to say that it's very likely there are many contested divorces, but because individuals cannot afford legal mobilization, they cannot afford litigation as a result in a relationship, one party compromised. One party has to give up more than the other party, and as a result, this couple end up at the Civil Affairs Bureau, right? So my point is litigation is really expensive, time consuming, and you need certain knowledge to explore the official justice system. So I just want to quickly take a step back and say, what is really contested and what is not is still something we need to look into. And as for the type of divorce or the kind of divorce finalized outside the court system, I personally don't know much about that type of divorce. And I certainly hope in the future, more researchers will look into that kind of marital dissolution.
So you mentioned a couple of tactics that judges use. Pressuring the plaintiff to withdraw, chasu, denying the first application for divorce so that they have to come back in time. And then you talk quite a bit about agenda setting, which is basically the judge ignoring things that the plaintiff wants to put into the litigation and just leaving them out. So let's talk about those three as what I think are the main ways that women are losing. The pressure to withdraw, you mentioned that was first spotted in like the late aughties, around 2009, as something that was going on, and it seems to have accelerated. Do you have a sense of where that comes from? Is that like just a practice that judges said, oh, hey, this works, and then it seems to help me keep KPIs up. I do better, on my year-end numbers, right? My performance statistics look better if I do this. Do you think it just kind of spread like that virally? Because there's no document that says, unless you hit a certain, and you may take your mouth off now, right? If the case doesn't have certain standards or something, you should try to get it withdrawn. How did that spread so quickly, so virally?
I really like this question. In fact, I put a lot of thoughts into this. Initially, I just noticed that judges tried really hard to pressure plaintiffs to withdraw their cases. I thought again and again and again, right, in the field work. And in interviews, and certainly in participant observation, I really didn't get a very satisfactory answer. And unlike other techniques, if we're talking about other judicial techniques, in interviews, it was just very clear to me that judges deploy certain techniques very deliberately and very consciously. But when it came to withdraw, very few judges brought it up in interviews. So I couldn't really didn't immediately understand why judges did this. In fact, I even remember around 2017, I was still asking Inch about withdrawal. I was asking her, hey, you were a former judge. Tell me why did this has spread it out? Why withdrawal spread it out? We saw that graph, right? And I think it was after I started looking into legislative and statistical records, I realized, hey, there are certain systemic explanations for why judges have increasingly relied on withdrawal to handle not only divorce cases, but other civil cases. And in chapter 5, I explained that, well, legally speaking, withdrawal simplifies court proceedings, because once someone withdraws a case, I don't have to deal with it. Organizationally, the Supreme People's Court, since 2000, I can't remember the starting point. I think it was around 2011, 2007, 2009, the Supreme People's Court started implementing certain measures to reward judges who could boost up their withdrawal rates. And by the way, the Chinese term 测速率 did not even appear until much later, around 2009, 2010 or so. So this is to say that for judges, organizationally speaking, they receive certain rewards if they could boost their withdrawal rates. And the larger context is that because withdrawal rates become part of the indicator, if you can turn away divorce petitioners, if you can turn away litigants, you're contributing to the harmonious socialist society, and that's the rationale behind SPC's measures, right? So organizationally speaking, judges see certain incentives behind their use of withdrawal, and also politically. Politically, withdrawal, when the SPC, when court system attach certain meanings to withdrawal, then politically withdrawal has gained certain political significance. So all this is to say that it seems to me initially this is just a very individual phenomenon. And over time, this become a collective problem. If we all do this as individuals, as a collective, we can benefit from this practice.
But as you observe, if somebody withdraws,
Yeah.
and they still want to get a divorce, they have to come back and they face the same. They don't get it. They don't get their fees returned to them, so they're already out of pocket for everything that paid the legal worker who's assisting them. They've already paid the court fee, and they've already obviously taken the time off from work to travel, the travel expenses to come to the court and file this case. And so then later when they come back, they simply have to repeat all of those expenses a second time, which they also have to do when the judge denies them the first petition. Could you talk a little bit about that phenomenon where that also seems to have become almost institutionalized?
Yeah, from the viewpoint of a divorce petitioner, right? Once you withdraw your case, the consequence is pretty dire. First, you can only take, technically speaking, you can still take part of your litigation fee back. I believe 50%. Once you withdraw a case, you take 50% back. But the problem is on your record, there will be a withdrawal. You won't get a denial of divorce. This means that next time you come back, file a divorce lawsuit, judges will still consider this as technically the first attempt for divorce. And we already know that in the first instance, judges are less likely to approve divorce. So you still have to sell, whether through the first attempt until judges reject your divorce petition, and then 6 months later, you come back and try it again. So this only extends the entire process, not to mention, once you pay a lawyer, you're not going to get the service fee back, right? And all the time, and expenses for transportation or lost income, like salaries and etc., you're not going to retrieve all these expenses, get these expenses back. So no, for divorce petitioners, withdrawal is hardly a good outcome.
How has it happened that judges now habitually seem to reject the first application? And so in the case, the story you just told of the woman who was pressured to withdraw, did not withdraw, insisted on moving forward, she was rejected. It was her first application. And this seems to have become very systemic. How did that process evolve and also become viral in a sense and become the established practice, even though it's not on paper anymore?
This is a really interesting question. He Xin, a law professor at Hong Kong University of Hong Kong, he was the first, to the best of my knowledge, who was the first one who wrote about this. He published an article in 2009, right? And he was the one who established that Chinese judges all too often reject the first time divorce petition. And then when litigants come back, when plaintiffs come back, and the second time when they try to get a divorce, they stand a better chance. And I think at the heart of this question is the mechanism or the process certain judicial practice or judicial behavior spreads out. And if we really want to get at that mechanism or process, I wonder what kind of research methods will allow us to capture this mechanism. And I really need to think long and hard about this research design. But what I can say right away is I suspect that judges initially did this just spontaneously, especially for judges who have to routinely deal with divorce, right? They are aware if they want to finesse their way through really difficult, highly contested divorce cases, perhaps the best thing to do is to, the first time I'm gonna turn plaintiff away. That way I can manage both the plaintiff and the defendant expectations. If you have to wait for 6 months, some plaintiffs will simply give up. Then I don't have, as a judge, I don't have to deal with it. Some will eventually come back. The plaintiff will come back, but the second time, the defendant, more too often a husband, would already have that expectation, my marriage probably would not survive. By that point, maybe both the plaintiff and the defendant have come to terms with the reality, their marriage will not survive. So I suspect that initially it's just individual judges who over the years develop this experience. If I do so, maybe it will become easier for me to handle really difficult divorce. And over time, that practice spread it out. And by 2018, the Supreme People's Court formalized this practice. And these days, when we talk about divorce cooling off periods, 离婚冷静期, we generally consider it as part of the non-contested divorce. So when you go to Civil Affairs Bureau to register your divorce, you have to wait for, you have to get through the cooling off period, right? It's actually, and that, by the way, that practice was formalized by the Civil Code, and the Civil Code came into effect in 2020. But long before the Civil Code introduced the cooling off period, it was the Supreme Court that finalized divorce cooling off periods in 2018. So around 2018, judges across the country were told that while they were dealing with divorce lawsuits, they could impose divorce cooling off periods on plaintiffs and defendants. So what He Xin described, a spontaneous practice among judges, by 2018 got formalized, or even you can even say institutionalized in Chinese courts. Now judges can formally phrase a divorce litigation and ask litigants, especially plaintiffs, to go away and then come back later. And then I'm gonna decide on this case.
But in that case, that's not rejecting the petition and requiring them to come back and refile, right? Okay.
Yeah, it's just cooling off period.
Cooling off
So
and coming back.
technically
Same
speaking, that's
claim.
not a rejection or denial of divorce.
Right. The third mechanism or tool that you described the judges using, this what you call agenda setting. That is really interesting because that's how the judges are setting the terms, right, of the divorce. Who has custody of the children? How is the property distributed, or is it even distributed, right? And this I found fascinating because we see it in other kinds of cases as well, right? And I think I was at least familiar with it more in, say, the political cases scenario. So cases that are frequently reported about in the media where you have a political dissident, for example, on trial, and that person may be trying to introduce evidence, or actually some of the wrongful conviction cases that have been quite, in the news. Defendant is trying to introduce evidence and the judge simply ghosts them, that ignores. It's as if they're not speaking, or may even, shut them down, stop speaking, But it's fascinating to see them doing that in this kind of, as you say, mundane, day-to-day. There's nothing political here. which is making me rethink its occurrence in those other settings. So judges feel empowered. It's my courtroom. I set the rules, and you just said something about wanting property, but I'm going to pretend you didn't say it.
Yeah.
How does this play out in the case of land? And I know Professor Alvarez will be very interested in this because he's doing some research on that.
Yeah.
Maybe I should start first with other kinds of property, non-land property. Maybe you
Yeah.
should speak about first, because
Mm.
that is contested. That is
Yeah.
actually dealt with pre-trial. Land, you said, doesn't even appear.
Yeah.
So can you talk
Sure.
about property?
In the book, I identify 3 types of power, right? Very often we focus on judges' formal decision-making power. This is to say that upon judging, judges must hand out substantive decisions. You get child, you get property, you get divorce or not, that kind of substantive decision-making. What we're less likely to notice is judges' agenda setting power. And by agenda setting power, what I mean is a very different kind of practice. Another term is non-decision making. By non-decision making, I do not really refer to inaction on part of judges. Quite as a contrary, non-decision making refers to judges' practices, oftentimes very active practices to suppress or to hinder women and or other plaintiffs to pursue certain rights. And this mostly takes place in the instances where women try to actualize their property and custodial rights. And in chapter 7, I use several tables to show litigation outcomes, right? And what's so noticeable is in most, I believe I have a sample of roughly 200 divorce cases. And among these 200 divorce cases, in roughly 70% or so, you simply don't see any judicial decision-making on property division. It's just completely missing. The either court judgment 判决书, or you pull out mediation agreements 调解书, and nowhere could you find any writing, any decision on property division between husband and wife. And you wonder why that's the case. It's not because women did not contest their property rights. Quite as a contrary, time again, I saw women vehemently contest their property rights upon divorce. What happened again and again is judges pressure women to give up their property, marital property altogether. So in so doing, judges hope that they could trade women's property rights for men's cooperation in divorce. So this is almost like for the wife, you give up property. For the husband, you sign divorce paperwork. That's the arrangement. So I use agenda setting power to illustrate how judges push women to give up certain rights. And land holding is an even more complicated matter. I use the 3rd type of power relationship to characterize what happened inside Chinese courts. The 3rd type of power, I call it conscious formation power. This is the type of power the state exercise in order to shape women's perceptions of their rights. So this is to say that state power oftentimes shapes not only what is conceivable, but also what is inconceivable. And what happened in the context of divorce litigation is that women don't even ask for land rights. And in interviews, in courtroom observations, in face-to-face meetings between women and their counsel, there simply was no talk of land rights. So I was really intrigued by the fact that women did not ask about land rights at all. So why didn't they even think about land rights? Turns out, again, in the final chapter, I argue that this has a lot to do with the fact that the PRC in the reform era has instituted a land regime. And in that land regime, there's enormous power differentials between women and men. And this land regime has further entrenched this gender structure as a result, it becomes almost unspeakable and unthinkable for women to contest land rights upon divorce. So in this instance, this is when people don't even realize, oh, landholding is part of my essential rights. It's so integral to my marriage rights. They don't ask, they don't contest rights in litigation, certainly not in the context of divorce litigation. That's the main finding and main argument.
When you talk to judges about what they're doing in divorce cases, did any of them ever acknowledge to you any of these methods that so the pressure to withdraw, denying the application, and in particular, this last approach of agenda setting and basically ignoring women's requests? Did any of them acknowledge that they were doing this and explain how it could be consistent with applying the law and meting out justice?
Yeah, I really like this question. I think when I was working on the book manuscript, on the one hand, I harbored a lot of bitterness, as you can tell, a lot of bitterness toward Chinese judges. On the other hand, in the back of my head, I certainly hope that I didn't portray them as a homogeneous group. And of course, judges vary in terms of their attitude toward rural women. I did come across one or two judges who were sort of sympathetic toward rural women, who were aware that the courts dealing with divorce lawsuits, they were aware how unfair and how problematic these practices were, right? And judges, by the way, virtually every single judge I talked to was very bitter about withdrawal and about mediation. They were not happy about the fact that they had to rely on mediation to deal with so many different cases. But on the other hand, I also should point out a lot of the judges I interviewed, a lot of the judges I interacted with were so blind to the gender disparities in divorce litigation. And a lot of them simply did not care about the rural women, especially migrant women's struggles.
And this includes female judges?
Including female judges. And I think I've several times people ask me, hey, what if this is a female judge? Will that make a big difference? I think both He-Xing and I argue, no, we have not seen that kind of gender differences among judges. This is to say that both male and female judges use very similar judicial techniques and tactics in judging. And I suspect this is the case because both female and male judges have to face the same organizational, bureaucratic, and political pressure. It's not like female judges would deal with situation. Well, suddenly they will have a very different institutional environment.
So I'm going to start taking questions in just a minute, but one thing has been bothering me as I was reading the book, we're constantly focusing on this gap between law on the books and law as it's practiced. And the law on the books, in many cases, is not bad, right? Maybe it could be tightened up. The language could be better. It could be clearer. You know, you could improve on it, but it is protective of women's rights. And so I'm wondering, should we think of the National People's Congress, the lawmakers, as being somehow more liberal than the judges? You know, if the lawmakers are providing for women to get compensation in cases of domestic violence, the lawmakers are saying that they should get half of marital property. They're saying that if the divorce is occasioned because of infidelity on the part of one party, there should be compensation. And there's a whole number of different behaviors, you know, gambling away all the family earnings, you know, you should get compensation. So the lawmakers are providing for these things. And of course, they're also providing for women to get custody of young children in many cases, which is denied them in practice. So are the lawmakers just a bunch of liberals that are not subject to these patriarchal influences that seem to be dominating the judges?
Well, certainly the Chinese state is not a monolith, right? So this is to say that some state actors are probably more sympathetic for women and feel more strongly about gender equality than others. And yes, if we just look at the marriage law on the books, it's a lot better than what we see in reality. But I just want to quickly point out, even if we just focus on the bladder law, it's not a coincidence that after 7 decades, the PRC's marriage law does not recognize land rights or couples' access to farmland as part of conjugal property. It's not a coincidence. This is a very conscious decision. And when you don't recognize land holding as part of conjugal rights, you cannot really ask the courts to partition land rights upon divorce. So it makes it harder for women to justify their pursuit of land rights upon divorce. Similarly, if we take a very close look at the type of property rights the marriage law protects, a lot of these property rights are based on an urban model. For example, right now, the marriage law has greater protection for intellectual rights, right? And well, if you're a peasant, you don't deal with intellectual rights, but there are other type of property rights you still need to, for example, homestand, 宅基地, we just talked about homestand. And there should be greater legal protections for women's rights to 宅基地. Do we see that kind of protection in the marriage law? No. So I guess I always try to produce sophisticated answers to say, yes, perhaps the National People's Congress has done a better job in terms of making laws, but at the same time, even the National People's Congress hardly, I would say, go as far as to protect, especially rural women's rights.
Well, they haven't done a good job in legislating if they've failed to take into account the unique nature of rural land, right? The fact that even the male doesn't own it. Right, that it's owned by the collective, and that's a whole nother complicated scenario. So they have not legislated in a way that was actually implementable, as we often hear males health wishing. It's not possible to implement this law because it simply doesn't fit. It's a round peg in a square hole. So do people in the room want to start raising some questions? So I'll give Professor Alvarez, our director, the first one, and then come to you.
So I'm curious if you could unpack a little bit why the Chinese government focuses so much on the family and marriage as a cornerstone for the society, and whether that has any relationship to the current aspect of encouraging more than one child. In other words, does it go back in any way to the child policy and problems about that? And I guess one response to the legislator, if the legislation knows, not in the detail you described, but knows more or less what's happening, they're being hypocrites. That is, and they're being hypocrites for very predictable reasons. After all, the rhetoric that the Chinese government portrays, in certainly the forums I pay attention to, the UN, is very much about protecting women's equality throughout. And these laws on the books is what China says to the CEDAW committee. Look, we're doing it. And it's harder to do your work, but it's not, I think, something the legislature doesn't know. That is, I suspect that there are some women who have had problems getting divorced who happen to be serving on those committees. And so so that is the sort of politics background that I'm curious if you want to say anything about. And connected to that is, given the amount of anger that must be out there from so many women who have had this experience, is there any kind of civil society manifestations to suggest that there's some inner frustrations that are coming out that have to be suppressed, or maybe they're going on? In other words, can you tell me a little bit about the consequences of this social?
Yeah, you asked 3 questions. The first one is why there is so much emphasis on marriage and family, right? And so much emphasis on the part of the state. I think there's a historical and an ideological, and the third one maybe practical reason or explanation. The historical explanation is, I would say, the Chinese Communist Party from its very start has learned how to use family as a key locale, or you may say use family as a key instrument to advance its political, military, and economical agendas. I would go as far as argue controlling the family to advance its agendas. It's an integral part of the Chinese Communist Party's governing toolkit. So that's the historical explanation. Ideologically, Chinese rulers, now I'm just even going beyond Chinese Communist Party. I would say ideologically, we can trace back all the way to Confucianism, right? The idea that family, state, the two are so intimately connected, and the state cannot really survive unless you have strong family. That political thinking has resonated so well with Chinese rulers, and certainly with the current one. I believe just recently I got a copy of Xi's talk. So this is a book that collects all the excerpts taken out of Xi's speech, and since 2012, and the book shows how many times in different instances she talks about family and the importance of restoring or enhancing family values and etc. Right? And so much so that the Chinese phrase 国家 literally consists state and family. You cannot really separate the two. You want state to be strong, the family must be sound and healthy. So that's the ideological explanation. And recently I joined a group of colleagues, and these are colleagues who have been thinking about China's social demographic crisis, right? You have divorce rates going up, marriage rates going down, and Chinese couples are just not producing enough babies. The birth rates have dropped to the lowest in 7 decades, and Chinese population has been aging very rapidly. And these social demographic crises will have, in fact, they already have important social political implications for both ordinary Chinese and for ruling elites. So what do? Of course, you have to, again, use family as a key site to make sure that the Chinese population reproduce itself, to make sure that women follow certain rules, so men can go out, and so to maintain certain gender regimes. Some feminist scholars would put it this way. So all in all, I would say yes, 3 explanations: historical, ideological, and very practical reason behind the state's emphasis on marriage and family. Your second question, I don't know how far I can go. I don't have data to indicate to what extent lawmakers are fully aware of what's really going on in the countryside, what's really going on inside the courts, right? And if they know, let's assume for a moment, they are fully aware of rural women's miserable experiences in Chinese courts, do they have the political will? Or even if they have the political will, do they have the power to push through important changes in lawmaking? That's another question I cannot really answer. Finally, I don't know if I can rely on my memory. You asked about civil society and how, let's say, if women fare so poorly in Chinese courts, right? Has the Chinese society, especially civil society, responded to such experiences? I've seen some developments. I've not done any systematic study in this regard, but my sense is For rural women, especially migrant women, it's really, really hard, in part because these women have been so sequestered. They have been, because of their participation in labor migration, they're not really able to form social groups and then to formulate collective action. In that sense, these women have been anatomized and making it really hard for civil society to step in and help these women. But it would be different if we're talking about migrant workers in general, especially those staying in metropolitan areas. These are groups, individuals who can access civil society. Their attempts at rights contention, I suspect, will generate different experiences and outcomes.
Thank you.
I would just pick up on the civil society point because there are a number of women's groups that have been very active in trying to change the village rules as they relate to women's access to land, for example, and their membership in the village collective, which is a factor here, and also very specifically on the domestic violence law, the implementation of the domestic violence law in the context of divorce, or even just in order to get protection from the husband. In my own work in the last 20 years, I worked with a number of these groups who held, and including actually the Women's Federation, Crude, held many trainings around the country with local officials, with police, with hospitals. How do you collect and preserve evidence of domestic violence? What is necessary in court? There've been trainings of lawyers and so on. And then there's a domestic violence hotline, at least one that I'm familiar with. There may be more local ones, but there's one nationwide one where they try to provide legal aid and support and, psychological as well as legal. So there's been a lot of activity on the side of civil society to try to push implementation. And I guess my question for you would be, what more could be done? I mean, obviously China is a huge country. And so the effort of, even if I add up the numbers of people involved in all of the work that I'm describing, we're still talking about, maybe thousands have been touched directly and then, more indirectly. But you do give examples, for example, of the domestic violence evidence collection, and which says to me that some of these trainings have had an effect. In other words, some of those women knew they needed to make the police give them a police record when they were being harmed, right? Because police aren't willing and they won't give a record unless, so some women knew enough to demand the record. Some women knew enough to collect the hospital records, to take photos of their own injuries and to bring all of that to the court. So those trainings have had some fruit. What more could be done? What more should be done? Is there some further point of intervention?
Yes, thank you for sharing some of the latest developments you just mentioned. They're new to me, right? And if I look at non-research findings and ask myself what kind of policy implications I can generate. Well, first of all, legal assistance or legal service. The women in my study, they did seek out legal assistance from professionals, but very few in the end received quality legal representation. So legal assistance is of great importance to women or to any disgruntled individuals in Chinese society. So access to legal services. And also in the book, I made it very clear that the PRC in the 21st century has hardly done enough to provide legal aid. So I'm talking about public funded legal aid to low income and the marginalized or the vulnerable group in society. So along that line, I would say the state should definitely invest more in legal aid. And also, I believe this goes back to civil society. Unfortunately, I've not seen many positive signs along that line. There's only more repression and only more efforts to push civil society, NGOs to the peripheral, or maybe even shut them down altogether, right? So I'm not very positive on that side, but I have seen, especially in my recent research on impact litigation and how NGOs, how lawyers, academics, medical professionals try to help LGBTQ groups. In that line of research, I've seen how civil society can make a huge difference, allowing the most vulnerable, the most isolated to get together, to organize, and to push their rights claims collectively. So this is precisely why the regime has tried so hard to repress civil society organizations, right? Because they work, they make huge difference. So these are, finally, as individuals, what we can do. I recently gave a talk at a different forum, and towards the end, I just emphasize, as individual citizens, what we can do is be fully aware of what rights we have. Even if just learn the black letter law, right? When you can pull out a marriage law and say, this is what the state law says, again, to village cadres, to local government officials, the fact that you can cite state law, still, that is a pretty powerful symbol. And I will not dismiss the symbolic value of state law.
So my name is Mom. So first, thank you so much, Professor Lee, for giving this amazing presentation and sharing your insight. I just have one quick question. So as you said, and I really agree that within the Chinese court, there is a political agenda to withhold this kind of like conception of a harmonious society. And basically that also got exemplified when like setting up the agenda terms where like women are persuaded to give up their property rights to men, so that like men will feel like, oh, divorce is more acceptable in that sense. And also like in Pushing's article, he also talks about how men in Chinese society as seen as like a disabling factor, so that it's better to pacify them to like prevent social unrest. But still, it seems like what the Chinese government cares about, or the court care about, is maintaining this kind of social stability. But what we've been seeing recently, like especially after the legislation on like the cooling off period, the 冷静期, there's huge public unrest, like discontent over these new rules. Do you think? And then I don't see like Chinese government respond to those kind of like public discontent like actively. Do you see there's like a deliberate ignorance in that they think maybe it's not as important, or they just like still keep on like trying to achieve their pragmatic goals of like having like more kids so that they have more labor force against this background of like growing gender consciousness within China?
Yeah, that's a really good question, right? And essentially what you're asking, this is my understanding, is how these interactions between state and citizens, between state and society, how that interaction plays out over time. The state wants to pursue its own agenda. Citizens are quite unhappy. Why are you telling me to wait for this period in order to get a divorce? I'm really miserable in my marriage, right? And I don't know the answer right now. And I've seen some statistics following the implementation of civil code, right? I've seen some statistics saying, oh, divorce rates are going down in this or that city. Fewer people turned up at civil affairs bureau. And because it's getting a lot harder to get a divorce, right? And now you have to go through all these bureaucratic steps in order to get a divorce. So it's possible that in the short time period, divorce cooling off period, that new measure may alter people's behavior. But in the long run, to what extent this new legislation can change people's behavior or their attitude toward marriage, I'm very skeptical. And here I should point out, this is actually not the first time Chinese authorities try to change people's behavior in divorce. In fact, in the mid-90s, the State Council, when it revised the marriage registration, it imposed a new restriction in the 90s. At that time, in order to get a divorce at civil affairs bureaus, it must turn in either an employer's 介绍信, or you must get a letter from village committees, villagers committees, 村委会. And that was a measure partially intended to lower divorce rates. And if we travel back to the 90s and take a close look, see if divorce rates actually went down. No, it didn't. So this is to say that official measures seeking to order people's behavior in marriage, sometimes it just doesn't work out. And even if you could, let's say, artificially lower divorce rates, does that mean ordinary Chinese takes marriage more seriously? This is just to say that there are limits in the state's attempt at controlling marriage and family. And in the book, I explicitly argue it actually takes certain institutional arrangements for the state to insert its influences in citizens' intimate lives. When these institutional arrangements are not around anymore, or these arrangements are vacant, the state will see its influence awakening in marriage and family life as well. So that's just what I can immediately say.
That's a helpful reminder, because I think often government action is presented as being in complete control. You know, like China's China's authoritarian, it can push a button, it can make people do things. And it doesn't necessarily work that way. There's been proposed amendments to the law on the protection of the rights and interests of women. They've been pending at the Standing Committee of the National People's Congress since early this year, I guess. Well, they had the first reading at the Standing Committee a year ago, December. And then we've seen 2 drafts of those amendments. And one of the amendments would give township governments a new role to sort of monitor the village rules for legality. So the village rules, as you know, are not actually laws, but they're very powerful. The 尊贵民约. And they often will state things like who's a member of the village collective, and therefore who has access to land, who has access to homesteads, who even qualifies to enjoy any of the collective property of the village. And as we know, those village rules frequently will say that females over the age of 14 or 16 are not part of the collective or should not be included in the allocations of homesteads and property. And now, if they are going to be given the role of ensuring that the rules are actually compliant with the Constitution and laws, those provisions, which women's organizations and the Women's Federation have been fighting for decades, have been trying to change for decades, village by village, actually, those would presumably be changed or could be changed. Do you have any thoughts about whether that could be accomplished? I mean, speaking of things that the government may want to do that it actually doesn't have the power to do. Do you think that if townships are given that role, they would actually take it on, or would they simply because of capacity, because of attitudes, patriarchy?
Yeah, thank you for asking that question. I actually wrote an op-ed for East Asian Forum, reviewing the most recent revision of that particular legislation. And in my review, I also touched on this issue. Basically, now lawmakers ask village cadres to come up with certain 村规民约. You cannot do this at the cost of women's land rights. That's the gist of that revision. And at this point, I'm very skeptical about the recent legislation. And I say this because this is not the first time lawmakers send out the message, hey, you should protect women's land rights. In fact, we can just take a look at the marriage law or the older version of the law on women's rights, protecting women's rights and interests. Even in the older version, there was already provisions about women's land rights, right? The problem is you can put all these rules on the books, but they're not really enforced. And more even so, the Supreme People's Court was also aware of the problem. In two different instances, some high-ranking officials as the SPC came out and explicitly say, we're aware of these problems, but in order to solve these problems, lawmakers should change law. So they basically pass the buck right back to the National People's Congress. And so I guess what I'm trying to say here is that what I saw in my field work, these were structural problems. By structural problems, I'm talking about how layers after another layers of power relationship have been entrenched in the PRC's land regime. You don't change these structural problems. Just changing the black letter law is not going to make much difference. So that's my my main reservation about the most recent revision of the law on protecting women's rights and interests.
You had a question, Professor Chan.
Yeah, thank you so much, Dika, for your presentation. I have a couple questions, and please excuse my ignorance of Chinese law and Chinese society. And you were talking about the withdrawal rate. You mentioned about the state and the party's goal of harmonious society, and you also mentioned about the bureaucracy considerations of the judges. And it seems to me that the two factors, bureaucracy, judicial bureaucracy, and harmonious society, well, a judge can fulfill the purpose of maintaining a harmonious society by persuading the parties to stay together. If the judge subscribes to the idea of so-called 劝和不劝离, that people should stay together rather than get divorced, right? So the so the judge can spend time and talk to the couples and persuade them to stay together. But apparently they don't do this, right? They'd rather save time and ask them to withdraw. So would you say that the factor, I mean, the bureaucracy factor outright the goal to maintain a harmonious society? That's the first of my question. I mean, if you have to choose which factor matters more than the other. And my second question is that what you have described is in a way similar to what happened here in the 1970s when the divorce revolution happened and women end up being worse after the divorce. And if women are forced to give up their property right in order to exchange for the husband's consent to divorce, they can do that outside of court. I mean, the woman can, well, I will give up everything as long as you agree to the divorce, right? So they can actually do it outside of court. So why don't they do it outside of court, but in the court? Because then there's no meaning for going to the court. I mean, the only thing that you can get by going to the court is to get divorced and lose everything, your property, your children. Why do you go to court? And so I'm quite curious why people still go to court. Is that because they are ignorant of what happened in the courts, or what? Because I'm quite in the choice of going to court and mobilize the law or not. And it's also possible that people mobilize the law outside of court, right? You can cite the law and say that, well, if you don't give me my share, I wouldn't, I mean, the woman, I wouldn't do this or what, otherwise I'm going to court, right?
Yeah.
Yeah, that's how people bargain outside of court.
Mhm.
Do this happen in China or not? Yeah, that's my second question. And my third question is a big one, and you don't have to answer. Do you think it's possible to have gender equality without democracy? Because what we are talking about is a big one. I know. Yeah. Because we're talking about the legislature who are not elected, right? And we are talking about judiciary.
Yeah.
Yeah, of course, in civil law society, judges are often appointed rather than approved. Well, anyway, so
Yeah.
you can ignore the last question.
I have some immediate reactions to your second question. So I'm gonna start with the second, then go back to the first. And I honestly don't know how I'm gonna respond to the third, but I'll try. I give it a try. So the second one, I think these are two very different. We're talking about, to respond to your question, there are two things that immediately come into my mind. One, yes, both men and women mobilize state law outside the court, and they can do so when they are when they are trying to figure out what to do with child custody, property division. So this is to say that even if they just go to civil affairs bureaus, they can still use state law to lay out all the terms, right? Because they can still approach a lawyer and ask a lawyer to write out all the terms for marital dissolution. So it's not like you have to go to court in order to invoke state law. And you asked me how come or why would women still go to the court if they end up losing all their rights, right? And this is my response. The women I interviewed, especially rural women, migrant women, very beginning of their legal mobilization, a lot of them were very hopeful. They were very optimistic. They truly believed in the Chinese government's propaganda. That law represents, law embodies. I go to law and law will protect my rights because that's what the state has repeatedly promised. And the women in my study, they have very limited education. They certainly didn't know that much about black letter law, but they had heard enough in TV, in broadcast, in newspapers that, hey, you go to the law is supposed to be impartial. The law is supposed to be fair, and the law will protect my rights. So I would say very, very few women in my study anticipated that, oh, you go through all the court proceedings and you end up losing all your rights. And this is precisely like the huge contrast between what they initially anticipated and what happened at the end of their litigation. That huge contrast broke so many women's heart, right? And it's like, you tell me one thing and then you go on doing another.
So there is no way for them to learn about this on the newspaper, on the internet. I mean, the information just.
I've not seen much media coverage of rural women's experience inside courts. Maybe there's media coverage about migrant workers' struggles to actualize their rights as laborers, but not so much about women's experiences in divorce litigation. And of course, their legal counsel, they hire legal professionals to represent them. And a lot of these legal professionals will not fully inform women, oh, this could possible, very likely this will happen to you at the end of your litigation. So to a lot of these women, this is their first encounter with the court system, and I'm afraid in many cases, this will be the last encounter because they are so disappointed by litigation outcomes. And your first question, here's my take on your question. It seems to me you're suggesting there is an ideological component. The the court or the state wants judges to contribute to the harmonious social society. That's the logical component. And then there's a bureaucratic component, right? Judges, we can put it this way, especially judges as a grassroots level, they're almost like street-level bureaucrats. And so it seems to me what you're suggesting is these two components probably clash, or at least the way you put it is maybe one carries more weight than the other. This is not what I've seen in my study. What I've seen in my study is that the SPC, the Supreme People's Court, somehow has figured out how to align these two elements. So in order to push judges to contribute to the harmonious society, socialist society, you must produce certain outcomes. And one of the outcomes is aggregate or boosted withdrawal rates. So this is to say that the SPC has used court system as a bureaucracy to push the judges to pursue certain ideological ends the state desires. So this is where ideological bureaucratic are actually aligned. So that's my observation in my study. As for the third, democracy, gender egalitarianism, I don't think I can say yes or no. I don't know if democracy is a must or a precondition for us to achieve genuine full gender egalitarianism. But what I can say here is without democracy, it's probably a lot harder. Or maybe I should put it this way, in an authoritarian context, it's going to be so much harder for women and men to achieve gender equality. It's so much harder because, at least again, in my study, what I've seen again and again is when the state tries to advance certain agendas, even in the instances where the state succeeded, the state often externalize the costs to ordinary Chinese, especially the marginal, the have-nots, and the vulnerable. So it's the poor, the women, and the most vulnerable part of the population who come to bear the brunt of the state's various agendas. In that context, I just clearly see the prospect of achieving genuine gender equality.
We're almost at time. I saw a hand.
Yes, the quick questions.
Very quick.
Yes. Oh, so I'm Yi-Chen from Taiwan, and I know the situation of divorce petitions in Taiwan. So I wonder, in China, do you know the husband or wife file more divorce petition more than the other? Which one is more try to file a divorce petition? Is the husband more or
And I
wife?
can add to your question,
Yeah.
that in Taiwan,
Uh-huh.
more
Yeah.
husband filed for
Yes.
divorce than wife, but that happened in the 1970s. Before the 1970s, more wife filed for
Okay.
divorce, but that's a tricky thing about that.
So I wonder in China, which one is more fights this?
Well, it's women.
And we're talking about divorce petitions,
Okay.
right? We're talking about divorce litigation,
Sure.
not uncontested divorce.
Okay.
In China, 70% or so
Hmm.
divorce lawsuits are initiated
Yeah.
by wives and not by husbands. And I thought, or at least right now I'm under the impression that this is hardly unique. In many other countries, it is women who pursue divorce more often than men. So I wonder if Taiwan is actually an outlier.
So-called judicial divorce, because we also have two kinds of divorce,
Yeah.
so-called consensual non-contested divorce and judicial divorce. Right now, I mean, it's a very complicated because we have a lot of transnational marriages. And yeah, a lot of these divorce cases come from transnational couples when the women have already left the country and the men want a divorce. Yeah, but there are also other factors.
That's a special
Yes,
case.
but can I ask the last question? You mentioned that you don't see any difference between female judges and male judges in divorce cases. And you know that there's a huge scholarship on gender and judging, right? The people discuss about whether the gender of the judge affect his or her decision. So would you say that the study of gender and judgment in China, at least in the case of divorce, is meaningless, or I mean,
I would
because
not,
because
yeah.
for like all these studies are conducted in countries where male judges and female judges are under the same institution and systems, right? But we can still study, I mean, the differences or whether or not feminist judging is possible. So,
So
yeah.
your question is it
it-
meaningful to
yeah.
add more women to the bench?
Or maybe to explore more about whether or not gender is a fact, the gender of the judge is a factor.
Is it worth studying?
Yeah, I mean, because according to your study, I mean, there's no difference, that it doesn't matter.
Yeah.
Yeah.
Yeah, of course, it's worthwhile, right? It's important for us to look into the gender of judges and see if it plays a role in judicial decision making. And this is where, as a sociologist, I would say, well, gender is not the only factor
And of
at
course,
play,
yeah.
right? And what I see in my field is, yes, sometimes judges are female, but they don't necessarily sympathize with women in their courtroom, in part because of huge, enormous class differences. Women, the female judges, these are college educated women, grew up in urban settings. And their litigants, these are rural women from the countryside. They don't even speak the same language. So much so that I remember in one divorce trial, a female judge in her 30s didn't even understand the dialect of the plaintiff. She needed a translator, someone in the courtroom, another villager, to translate the plaintiff's words so she could understand what exactly the villager was talking about. So that urban-rural divide, plus on top of that, class differences, they have very different educational background. All of these factors also come into play. In the end, gender plays much lesser role in shaping litigation outcomes.
Well, I'm afraid we are at time, so we'll have to end here, but thank you so much. That's been a fascinating discussion, and we'll have to have you come back and talk about some of the other subjects that you've been doing research on. Thank you so much.
Sure, thank you for having me.